Welcome to another deep dive from Talk Testimonies, where we break down complex Supreme Court cases. Today we're looking at a case that really gets to the heart of treaty rights. We're talking about hunting rights specifically, and how those rights intersect with statehood and the management of federal lands.
Yeah, this is a fascinating one. So basically, the court had to decide whether an earlier ruling from a federal appeals court, the 10th Circuit, about treaty hunting rights for the Shoshone Bannock tribes should also apply to a similar claim brought by a member of the Crow tribe.
Right, so there's this concept of issue preclusion at play here.
Exactly. And that's what makes this case so interesting. The state of Wyoming was essentially arguing that the question of treaty-based hunting rights, specifically on lands that they considered unoccupied within Wyoming, was already settled by that earlier 10th Circuit ruling in a case called Repsus. So because of that, they argued that this new case, brought by the Crow tribe member, shouldn't even be heard.
So why was the Crow tribe member arguing that this case should be heard then? What were their arguments against applying issue preclusion here?
Well, the petitioner who was representing the Crow tribe member made several arguments. They said that the specific argument that the creation of the Bighorn National Forest itself had terminated the treaty right, that argument was brought up really late in the Repsus case in the 10th Circuit. And there really wasn't much detailed legal argument about it.
Okay, so not enough time to really consider it fully.
Right. And they also argued that the 10th Circuit's decision on this specific point regarding the National Forest, it didn't really go through a full review process by the higher courts.
It's almost like it was just kind of a side note in the broader decision.
Exactly. In fact, the petitioner even suggested that the state of Wyoming might have kind of like forfeited their right to even bring up that argument.
Yeah.
Because it wasn't properly raised in the lower courts.
I see. Yeah.
And this, led to some interesting questions from the justices, like Justice Alito. He wondered whether there had truly been a full and fair opportunity to argue this specific point about the National Forest back in the 10th Circuit, especially given the lack of detailed legal arguments presented in the briefs.
So essentially, was the 10th Circuit's decision on this specific point something that should even be considered binding in this new case?
Yeah, that's a key question. And Justice Kagan actually brought up the possibility of just sending that whole question of forfeiture, whether Wyoming had given up the right to make that argument back down to the Wyoming state courts to figure out.
Punt it back down.
Yeah, basically. But the petitioner representing the Crow tribe member, they pushed back on that. They argued that that's not really what the Supreme Court typically does when an issue hasn't been, fully raised and argued in the lower courts. They kind of stick to the record as it is.
Okay, so a lot of back and forth on this issue preclusion stuff.
Absolutely. And it highlights just how complex this area of the law can be. Even Justice Alito himself acknowledged that it's a topic that could easily take up a couple of classes in law school.
And to really untangle this issue preclusion argument and understand how it applies or doesn't apply to this case, we need to go back in time a bit. We need to look at some important Supreme Court precedents, starting with Racehorse, a case from way back in 1896.
Right. Racehorse is super important here because that case basically concluded that the Shoshone Bannock tribe's treaty right to hunt on, quote unquote, unoccupied lands within the United States, that right ended when Wyoming became a state. And their reasoning for that, well, it rested on a couple of key legal concepts. One is the equal footing doctrine. This is the idea that all new states that enter the Union, they should have the same rights and sovereignty as the original 13 states.
And how did that apply to treaty rights?
Well, the Racehorse Court viewed treaty rights as being, in their words, temporary and precarious. They saw statehood as a kind of culminating act that would extinguish those rights in favor of the new state sovereignty.
So that was 1896. But legal thinking has obviously changed since then. A lot of people today would view treaty rights very differently.
Right, and that's where Millax comes in. It's a 1999 Supreme Court case that really challenged those assumptions in Racehorse. The Millax decision basically said, hold on, statehood doesn't automatically wipe out off-reservation treaty rights. And they directly questioned that whole temporary and precarious characterization of treaties.
But didn't Millax also say that it wasn't overturning the Racehorse decision outright?
That's the tricky part.
Yeah.
They didn't overturn the specific outcome of Racehorse, but they did reject the core legal reasoning that Racehorse was based on.
Okay, so this creates a complex situation where there's this old precedent that's still technically on the books, but whose legal foundation has been seriously weakened. So how did the petitioner in this Crow tribe case use Millax to their advantage?
Well, they argued that, look, while Millax might not have explicitly gotten rid of the racehorse outcome, it pretty much rejected all the legal underpinnings that led to that outcome. This includes that whole idea of the equal footing doctrine automatically terminating treaty rights upon statehood.
But then Justice Kavanaugh pointed out that Millax did specifically uphold one aspect of Racehorse.
Right. He emphasized that Millax did preserve that specific racehorse conclusion about the treaty language, that the right to hunt on unoccupied lands of the United States was, in fact, ended by Wyoming's statehood. And that was based on what Congress seemed to intend when they made the treaty and when Wyoming became a state.
So how did the petitioner respond to that?
Well, they tried to make a distinction between the Crow Treaty and the Shoshone Bannock Treaty at the heart of the racehorse case. They were saying, look, there are factual differences between those treaties and the negotiation histories and what happened after they were ratified.
Like what kinds of differences?
Well, they argued that there's no real indication that statehood was ever meant to end the Crow tribe's specific hunting rights, unlike what the court found in Racehorse for the Shoshone Bannock Treaty. But Justice Kavanaugh pushed back on this a bit.
He wanted more specifics.
Exactly. He wanted to know, okay, what are the actual differences in the intent behind those treaties? Especially since both treaties use the exact same language about unoccupied lands. And the petitioner admitted they didn't really know that much about the specific details of the Shoshone Bannock Treaty history as it was presented in the Racehorse case.
So what was the U.S. government's position on all of this?
Well, the government, acting as amicus curiae, or friend of the court, actually made a bold argument. They said that the court should just overrule Racehorse directly.
Wow, just get rid of it.
Yeah. They said its reasoning was wrong and shouldn't be applied to this case with the Crow tribe, even though the language in the treaty is identical.
But if they overrule Racehorse, wouldn't that create uncertainty for how other treaties with similar language are interpreted?
That's a valid concern. And Justice Sotomayor pressed the government on that point. She wanted to know, okay, what are the concrete historical differences between the tribes that justify treating their treaties differently? But the government basically admitted that their main argument was that Racehorse itself was just wrongly decided.
Interesting. So they focused on what the treaty itself laid out as the conditions for the hunting rights ending, right?
Exactly. Things like the land being occupied by settlers, which would make it no longer unoccupied. Which, of course, brings us to the big question of what exactly does unoccupied lands mean in these treaties?
Right, because that seems to be a key point of contention in this whole case.
Absolutely. The government argued that unoccupied has a pretty straightforward meaning. They said it just means land that's not settled by people. But then Chief Justice Roberts brought up national forests. And he asked, well, what about those? Does the government occupy national forests, even though people aren't living there in the traditional sense?
Right, because the federal government manages and controls those lands.
Exactly. And the government responded by saying that, well, yeah, the federal government could be considered to occupy land by preventing private settlement. So in their view, a national forest could be considered occupied in that sense. But they also emphasized that the same standard should apply to all U.S. property in Wyoming.
So did they propose any kind of rule for determining when land is occupied?
They actually did. They suggested a regulatory standard 150-yard buffer zone around any buildings or campsites. So in their view, if you're within that 150-yard zone, the land would be considered occupied and hunting wouldn't be allowed.
Interesting. So essentially the federal government could be considered to occupy land without having physical structures on it, just by regulating it, controlling access, and preventing private settlement. But that wasn't Wyoming's position, was it?
Not quite. The state of Wyoming had a different interpretation of occupied. They argued that it should be understood in the historical context of how people thought about land ownership back in the 19th century. And in their view, that included the federal government setting aside land for things like reservations or national forests, even if there weren't any buildings or permanent settlements there.
So just the act of designating it for a specific purpose by the government was enough to consider it occupied.
Right. But Chief Justice Roberts seemed a bit skeptical of that. He pointed out that this interpretation basically replaces the common meaning of unoccupied with something entirely different. And Justice Sotomayor, she raised another important point. She wanted to know where in the treaty does it actually say that statehood, in and of itself, ends those treaty hunting rights.
Because the treaty itself seems to focus on things like the disappearance of game or the land being occupied by settlers, not specifically statehood.
Exactly. But the state doubled down, saying that Racehorse, that earlier decision, already concluded that unoccupied lands in the treaty referred to a specific type of land, kind of like hunting districts. And these districts, according to the Racehorse Court, ceased to exist once there was enough settlement by non-Indians, which ultimately led to Wyoming becoming a state. And of course, the federal government had a hand in facilitating all of that settlement through things like the Homestead Act.
So a lot of history coming into play here, shaping how we interpret this one phrase, unoccupied lands.
Right. And the case also raised some important practical concerns about conservation and the state's ability to manage hunting on its lands, especially within national forests.
Because Wyoming was concerned that if the treaty rights were upheld, it would limit their ability to regulate hunting in a way that protects wildlife and ensures public safety.
Exactly. They expressed concerns about potential conflicts between what they need to regulate and what they might be allowed to regulate under the treaty. They worried about having to constantly prove a very specific conservation need to justify any regulations. It's almost like a reverse preemption, where the state's authority is pushed aside unless they can make a really strong case for a specific need.
And how did the court respond to that?
Well, Justice Breyer brought up the Yakima Treaty cases as a potential point of reference. In those cases, the court found that, generally speaking, ordinary state regulations related to things like public health, safety, and the environment, those aren't typically blocked by treaty rights.
So states still retain a fair amount of authority to regulate those things.
Right. And the state of Wyoming acknowledged the Crow tribe's right to hunt for subsistence purposes, and that the federal government could grant those rights within the national forest. But their argument was that the state's existing regulatory authority in the national forest, which comes from the Organic Act, the law that created the national forest system, that authority itself is actually a form of the federal government occupying the land. So it's not that the treaty right is being repealed or canceled outright, but that the state's regulations are essentially acting on behalf of the federal government, which is, in a sense, already occupying the land. It's a really nuanced argument.
It really makes you think about how something signed so long ago, a treaty, can still be the subject of such intense legal debate today.
Absolutely. And the implications can be really significant. In this case, the court really grappled with what constitutes a big enough change in the legal landscape to say, okay, issue preclusion doesn't apply here.
Because things have changed a lot in how we think about treaty rights since those older cases like Racehorse.
Right. And the petitioner argued that the shift away from that equal footing doctrine as an automatic treaty terminator, a shift that was really highlighted in Millax, that definitely represents a major change in legal thinking.
Enough of a change to revisit this whole question of hunting rights on lands that are now national forests.
Exactly. But the state argued back, saying, look, you need a major doctrinal shift to avoid issue preclusion. It's not enough to just question an old precedent. And Justice Gorsuch really pushed them on that point. He wanted them to define, okay, what exactly is the standard for a major doctrinal shift? How do we know when we've crossed that line?
What a great question.
Yeah, it's a crucial one. Justice Breyer also weighed in on this. And he suggested that Millax, by rejecting those core aspects of Racehorse, that automatic termination of treaty rights upon statehood because of the equal footing doctrine, that was a big enough change, a major doctrinal shift, even if Millax didn't explicitly say they were overruling Racehorse's outcome.
So essentially, the reasoning behind the old precedent had been so thoroughly dismantled that it was essentially overruled in practice, even if not in name.
Exactly. And the petitioner brought up other cases as well, like Limbach and Sonnen, where the Supreme Court had effectively overruled earlier decisions without explicitly saying they were overruling them at first. So it happens.
So fascinating how much weight we give to these old precedents, especially in an area of law like treaty rights, where our understanding has evolved so much. Now let's get to our favorite part, the 10th chair segment.
I always love this part.
So, if you were the 10th member of the Supreme Court hearing this case, where do you think you would have landed? How would you have voted?
If I were that 10th justice, I think I would lean towards the argument that issue preclusion shouldn't apply here. And the main reason for that is that shift in the court's thinking that we've been talking about. The legal landscape has evolved so much since Racehorse, particularly in light of Millax. And while Millax didn't explicitly overrule the Racehorse outcome, it really did dismantle those legal foundations that the decision was built on. Mm-hmm. So to hold the Crow tribe to a decision that relies on such outdated legal ideas, it just wouldn't feel right. It would feel like we're perpetuating a flawed understanding of treaty rights and how tribal sovereignty and statehood interact.
You're essentially saying that clinging to that old precedent would do more harm than good.
Right. And I think the fact that that specific argument about the national forest terminating the treaty,
Yeah.
right, the fact that that received very limited attention in the 10th Circuit, both in the legal briefs and in the actual review process, that also supports the argument that the Crow tribe hasn't really had a fair chance to fully argue their case on this point.
So you'd want to see that happen, a fresh look at their treaty rights with this new understanding of the legal issues at play.
Exactly. With a fresh consideration of the Crow tribe's treaty rights that takes into account all these changes in the legal landscape and the court's more modern approach to interpreting treaties.
That brings us to the end of our deep dive into this really fascinating Supreme Court case. It's a great example of how complex and nuanced these issues can be, and it shows how important it is to consider historical treaties in light of evolving legal principles.
Yeah, it's a reminder that law isn't static. It's always evolving.
We hope this deep dive gave you a clearer understanding of the arguments and all the subtleties involved. And we encourage you to keep thinking about these issues. What aspects of treaty interpretation did you find most compelling? What questions are still swirling around in your head? These are vital legal and historical questions, and we encourage you to keep exploring them.